Welcome to yet another important video. In this video, we shall find out whether cash can be seized during search and seizure proceedings in GST. As you know, the provisions relating to search and seizure are contained in Section 67(2) of the CGST Act 2017. Section 67(2) empowers proper officer not below the rank of Joint Commissioner to authorize any other officer in writing to search and seize if he has reason to believe that any goods liable for confiscation or any documents, books or things that are useful or relevant for any proceedings under this act are secreted in any place. So far as goods liable for confiscation and documents or books are concerned, there is hardly any dispute or confusion. But the problem arises because of the use of expression the things. Now, things are not defined anywhere in the GST law. So the problem of interpretation of things arises as to what exactly are covered under this expression. Whether cash or currency can be seized on the pretext of being included in things? Let's find out with the help of judicial pronouncements so far in this regard. One of the leading cases on this point was the Honorable Madhya Pradesh High Court judgment in the case of Kanishk Matta versus Union of India. In this case, the Honorable High Court held that the expression things include cash also. So the GST authorities are authorized to seize cash. There have been a lot of judicial developments after this judgment. Recently, the Kerala High Court in the case of State Tax Officer versus Shabu George has held that cash cannot be seized, especially when cash does not form part of stock in trade of the business. The court further held that observation of GST authorities that huge amount of cash was lying in the business premises as idle and not deposited in bank is beyond their powers and jurisdiction. Accordingly, cash was ordered to be returned. It may be noted that the department's SLP against this decision has been dismissed by the Honorable Supreme Court, wherein the Honorable Supreme Court has declined to interfere with the High Court decision. So accordingly, this decision of the Kerala High Court has attained finality insofar as the seizure of cash from business premises is concerned. In another leading judgment of the Kerala High Court, again in the case of Dhanya Kumari versus State Tax Officer, it was held that no cash can be seized from business premises of the taxpayer, especially when the same does not form part of stock in trade of the taxpayer. In this judgment, the Honorable Kerala High Court relied upon its earlier judgment in the case of Shabu George and accordingly directed the respondent to return the cash seized. Another leading case on this point is that of Arvind Goyal versus Union of India. In this case, the Honorable Delhi High Court held that seizure of cash is illegal and without authority of law, as documents, books or things can be seized only to the extent they are relevant or useful to the proceedings under this act. It is difficult to comprehend how currency or cash be useful or relevant for the purpose of proceedings under this act. In the recent case of Rajiv Chatwal versus Commissioner of GST, it was laid down by the Delhi High Court that currency available in the premises is not a subject matter of seizure under Section 67(2). Section 67(2) does not empower any such seizure. So in this case also, it was held that cash cannot be seized. In this case, the Honorable High Court relied upon its earlier judgment in the case of Deepak Khandelwal, wherein it was held that proper officer cannot seize cash or other valuable assets. From the legal point of view, it can also be argued that the definition of the term goods under the GST law does not include money. Since cash is one of the forms of money, from this point of view also cash cannot and should not be seized. So we have seen that a number of judgments after the decision in Kanishk Matta's case, and in those decisions it has been held that cash or currency cannot be seized. We have also noted that in Shabu George's case, the SLP against Honorable Kerala High Court judgment has been dismissed by the Honorable Supreme Court. Thanks for watching the video. If you are new to the channel, don't forget to subscribe the channel and hit the bell icon to get latest cash tax law updates, query resolutions, case law analysis and a lot more. Thank you.